Supplementary cost list, item number 9.
May please, Your Lordship. My Lord, the genesis of the case is that there are several land acquisition cases, the judgment and order passed by the Lanat Additional District Judge Scholarship, which is 17/12/2024. Now, after the passing of that judgment and order, there was a judgment and order passed by the executing court, which is at Annex 1. Your Lordship may kindly first come to the original judgment and order passed in LA case number 15 of 2015. That is at page 30. This is the judgment and order 17/12/2024 passed by the Lanat Fast Track Court cum Additional District Judge. Now, my Lord, the operative portion is at page 48. At para 15, page 48, the Lanat Trial Court has directed payment of compensation, my Lord, which I'll read it with your Lordship permission.
Yes.
The claimants, namely Mr. MOS, shall be paid compensation that appeared in the apportionment section of the award number of 3 of 2014 dated 23/4/2015 for damage caused to his house building. Claimant Thang Ying lawyer shall also be paid that appeared in the apportionment of award number 3 of 2014 dated 23/4/2015 for loss of crops. This court opined that 2 years multiplier shall be appropriate multiplier considering no specific evidence about the yield of plantation crops fish ponds. Therefore, both the claimants shall be paid compensation as mentioned in subclause 1 and 2 of this order multiplied by 2. They shall also be paid solicium at 30% and interest at 12% per annum from the date of notification under Section 4 of the LA Act to the date of pronouncement of this award. Now, my Lord, being aggrieved with this order, we have filed LA appeal before this honorable court. Now, your Lordship may kindly come to page 50 of this petition, my Lord. We have filed LA Appeal 5 of 2025 along with interlocutory application. Now, this honorable court has issued notice on 13/8/2025 under Section 5 of the Limitation Act, my Lord. So we have challenged the order 17/12/2024 passed by the Lanat Trial Court in LA case number 15 of 2015. Now, due to the submission of the Lanat Council for the claimant before the trial court, executing court, they have submitted an execution petition. Now, this impugned order today, my Lord, that is at Annex 1, has been passed by the Lanat Trial Court cum Executing Court. That is on page 19, my Lord. It starts from page 19. The judgment and order dated 11/9/2025. It's at page 19 to 25. Your Lordship, with your permission, may I read the last 2 paragraphs? That is at page 24. Para 11. With your Lordship permission. Accordingly, it is hereby ordered that the properties, movable and immovable machineries, belong to the judgment debtors, that is PWD Mizoram, be attached forthwith with the assistance of Scholarship District Police Force. Meanwhile, detention in civil prison of the judgment debtors is hereby deferred until further order. The attachment order in detail is prepared in separate sheet. Now, the order of attachment is at page 26, my Lord, 26 and 27. Your Lordship may kindly come to page 27. Has Your Lordship got it? With Your Lordship permission, there are particulars of properties which are attached and mentioned in this order 11.9.25. Static road roller machine located at Konpui, which is estimated at 9 lakhs. And vehicle, here the Lanad Trial Court has directed that vehicle, if any attached by this order, shall be placed, kept within the court premises. Theft, damage, loss, or otherwise, if any cause to the property during the attachment period, shall not be the responsibility of the holder executing court. Now at page 28, my lord.
Mm.
28 from fourth paragraph from the top, my lord. The officer in charge, scholarship, Konpui Varante Police Station shall ensure that no theft, damage, or destruction is caused to the properties during attachment. The judgment debtor shall be held responsible for any damage, disturbance caused to the properties during the attachment. The judgment debtor is hereby prohibited from transferring the said properties by sale, gift, mortgage, lease, or other ways of creating any charge or encumbrances over the properties. All persons are hereby restrained from taking any benefit under such unauthorized transaction, if any. If in case of an offense against the public servant who will discharge his duties is brought to the knowledge of the court, the same must be dealt with stringently in accordance with law. Now, my lord, this 11.9.2025 judgment and order has been challenged before this honorable court, because one of the grounds is that the Lanad Trial Court cum executing court has not properly heard our case before the executing court while placing our submission, my lord. Now, due to the attachment of these machineries which is needed for public work, all the development activities and public work has been stalled. And in fact, my lord, the office of the SE, PWD, has been attached and kept under lock and key, which I may show your lordship, that is in my IA, which comes with this appeal, my lord. Page 15, my lord. This is the office which has been kept under lock and key, my lord. Our office has been kept under lock and key as per the direction of the Lanad Trial Court cum executing court, my lord, at page 21, para 6, which is the prayer made by the counsel for the decree holder, my lord. Now, my lord, my main grounds of appeal and the stay, which has been filed under Order 41, Rule 5, is more or less similar. So if, with your lordship permission, I would argue upon the grounds of appeal which I have taken in the RFA, my lord. If your lordship will see the order of attachment 11.9.2025, even though there was a prayer made by the counsel for the decree holder that the office of the SE should be attached and kept under lock and key, your lordship may kindly come again at page 27, my lord. Page 27. The particulars of property to be attached. In the main appeal, my lord. Here, the office of the SE, PWD, has not been mentioned, my lord, even though it was kept under lock and key.
Page number?
Page number 27.
of
The order of attachment in the main appeal, RFA. 27, my lord. I'm sorry, I have to take a lordship here, back and forth, my lord. Your lordship will see this in the order of attachment 11/9/2025, my lord. Here, your lordship has seen that our office has been kept under lock and key. However, in this order of attachment, the office was never to be attached, as it appears in this. Now, apart from that, my lord,
anybody for the department? Have you furnished? No, you were for the department.
no, I'm for the state today,
State. Yes.
as a private counsel.
Yes, yes, yes.
Now, my lord, today I'm praying for a stay of that impugned judgment and order dated 11/9/2025, along with this order of attachment, my lord. Because due to the attachment of our office and several of machineries which is used for the development projects of the public, all the development works has been stalled, and there is lots of hue and cry among the public that the road condition of that district is in a deplorable condition and it is in a dilapidated condition. And when the machineries which has been used for the development of public works has been attached, my lord, it is not only in the interest of the department, it is also in the interest of the public at large that this attachment has to be stayed, my lord. Since our office has been kept under lock and key, we cannot function administratively and financially, my lord. We have several liabilities to our contractors. All the development works and the project which has been proposed to be executed has been stalled, my lord. If I may take a lordship to my main grounds, my lord, page 9, starts from page 9. If your lordship may be kind enough to look at these grounds which I have mentioned in page 9 to 14. My lord, may I read with your lordship permission? For that the landed trial court cum exiting court erred in law and in effect in passing the impugned judgment order dated 11/9/2025 and the order of attachment dated 11/9/2025 in execution petition number 1 of 2025 arising out of LA case number 15 of 2015. Point number 2. For that the landed trial court cum executing court erred in passing the impugned judgment and order dated 11/9/2025 and the order of attachment dated 11/9/2025 in execution petition number 1 of 2025 arising out of LA case number 15 of 2015, despite the fact that the appellants have made a challenge to the impugned judgment and order dated 17/12/2024 in LA case number 15 of 2015 before this honorable court. For that the landed trial court cum executing court had failed to provide sufficient opportunity to the appellants herein to project their case, and this has caused severe prejudice to them. The appellants have suffered substantial loss due to the attachment of the Office of Senior Executive Engineer, Public Works Department, PWD, Scholarship Division, Scholarship Mizoram, and various machineries for maintenance of public infrastructure. It may be mentioned that the said Office of Senior Executive Engineer is charged with executing and maintaining critical public infrastructure, and therefore closure of the same is adversely affecting the development works of the public. Further, the order of attachment dated 11/9/2025 triggered a catastrophic halt to all development and maintenance, which directly jeopardized public projects with a total financial outlay of rupees 172.87 crores. For that the impugned judgment and order dated 11/9/2025 and the order of attachment in execution petition number 1 of 2025 has frozen the execution of time-bound projects and mandated activities plunging the district infrastructure development into paralysis. It may be mentioned that the works currently under execution, such as road connectivity projects under PMGSY, SASKI, and NABARD construction, and strengthening of state highways and major district roads, Bridge construction with a total value of rupees 151.92 crores are now completely halted. Further projects with administrative approval and secured funds amounting to rupees 20.95 crores cannot commence. Further, the Land Trial Court cum Executing Court could not have hastily directed for attachment of the properties, as there are other alternatives or remedy that may or can be exhausted as per law. Due to the attachment of the vehicle of the appellants, the officials are rendered incapable of inspecting critical project works and to verify work for processing, running account bills, finance bills. As such, this would adversely impact the standard works of project worth crores, and there are high possibilities of breaching contract agreement. Further, the Land Trial Court cum Executing Court had failed to exercise its judicious mind while passing the impugned judgment and order dated 11/9/2025 and the order of attachment in execution petition number 1 of 25, inasmuch as the attachment of the office of the Senior Executive Engineer, PWD, Scholarship Division Scholarship, has technically suspended all administrative and financial functions. Further, the said office is prevented from payment of salaries and contractor bills, including processing and depositing income tax deduction at source on salaries and contractor payments, violating the Income Tax Act 1961 GST, TDS on contracts violating the Central GST Act, labor cess under the Building and Other Construction Workers Act, and halting of e-payment files. Further, due to the closure of the said office, the mandatory progress reports of central government schemes, such as PMGSY, cannot be submitted, which will lead to immediate stoppage of funds from the Government of India. Now at page 13, further, the Land Trial Court cum Executing Court had failed to properly appreciate the submission of the Land Council for the appellants. The Land Trial Court cum Executing Court failed to appreciate and assess the wider ramifications of attachment of the movable and immovable properties of the appellants, inasmuch as it completely paralyzed the public work. It may be mentioned that stoppage of work on projects worth rupees 172.87 crores and potential lapse of sanctioned funds would result in substantial loss to the state exchequer and the public welfare at large, unless the impugned judgment and order dated 11/9/2025 and the order of attachment dated 11/9/2025 in execution petition number 1/2025 is set aside, it will cause irreparable harm and injury to the appellants and to the public in general. Further, the Land Trial Court cum Executing Court could not have taken such drastic action when it was seized of the fact that the appeal against the impugned judgment and order dated 17/12/2024 in LA case number 15 of 2015 is also pending before this Honorable Court. Now the executing order has arisen due to the alleged non-compliance of this judgment and order dated 17/12/2024. However, there is an appeal pending against this judgment and order, my lord. So, if I may be fair to submit that, yes, the Land Trial Court cum Executing Court can pass a direction which is well within his power, but it has failed to assess the wider ramification with regard to the attachment of the office of the SE and the machineries, which is not only the machineries of the office of the department alone, it is for the public at large, my lord. And there is an appeal pending, my lord.
But Mr. Counsel, very recently,
Yes.
Supreme Court has passed on judgment
Correct.
directing the executing court to execute the decree within a period of 6 months.
Yes, I understand, my lord. Now, the executing court is also beyond the limit of that 6 months. It has reflected in the order itself. It has to be supposed to be completed in September, but it has not been completed, and there is an appeal pending. If I may take your lordship to Order 41, Rule 5 of CPC, which your lordship knows very well. Now, it is the discretion of this honorable court to stay the execution, my lord, order. Now, if I may read this, my lord. Order 41, Rule 5, an appeal shall not operate as a stay of proceedings under a decree or order appeal from except so far as the appellate court may by order nor shall execution of a decree be stayed by reason only of an appeal having been preferred from the decree. But the appellate court may for sufficient order stay of execution of such decree. My lord, what is that sufficient cause?
Order 41 rule,
5. Order 41, Rule 5, subclause 1 is what I'm reading right now. Now, this other court, the appellate court, can stay the execution of such decree for sufficient cause, and that sufficient cause may arise, as we can see from Order 41, Rule 5, subclause 3. Order 41, Rule 5, subclause 3. If I may read with your lordship permission.
oh, not necessary.
Because here substantial loss may result to the party. If substantial loss may result to the party, stay can be granted. To substantiate my submission, my lord, I would like to rely upon the judgment of the Honorable Supreme Court with regard to execution, my lord.
Of which year?
2008, but I have that recent judgment also, but my first citation is 2008, 10 SCC 796. Rajaram Prasad Gupta and
It is
another.
there, but the recent decision of the Supreme
Yes,
Court.
I have that. I have that also. That Perry Yamal case. But here, what I'm trying to impress upon your lordship is at page 797. Para 4. It is well settled that in cases where the subject of suit is residential premises and the judgment debtor is residing in it, prayer for stay is ordinarily granted. Now here,
Remember?
para 4, page 797. Now, it talks about the grant of stay in residential premises. Now, in our case, this is the office of the superintendent engineer where we work and go to there every day to perform the function, official function for the public. All the administrative work and financial work cannot be done when the office has been closed. So, when the Honorable Supreme Court has laid down that in cases of residential premises, which also includes, according to my understanding, this office, when it has been occupied,
No. How residential accommodation and the office is same?
no, I'm giving a wider interpretation, my lord.
Residential accommodation has a different connotation.
It has a different connotation. However, my lord, since our office has been put under lock and key, we cannot perform the administrative and financial function. Now, your
But,
lordship,
why you have failed to honor the decree?
my lord, since we have objection with that award, the award by which the impugned judgment and order has been passed, 17/12/2024, because that award has been revised. The learned trial court has,
Then why you have failed to file the appeal?
no, we have filed an appeal. We have filed LA
File
appeal.
appeal, but the delay is yet to be condoned.
Yeah, delay is, I agree with your lordship.
Uh,
Delay is yet
you
to be
are,
condoned.
you seems to be not serious.
No, since the pendency, during the pendency of this appeal, the Learned Trial Court cum executing court has passed an order of attachment when it was seized of the fact that an appeal is pending. Your lordship will see that the
No,
13
unless
8
the stay is granted, why the trial court, why the executive court will stay the order?
my prayer here is that it can stay the machineries, but at least why it has stayed the office where we have to do our
Okay.
administrative function.
We'll
My lord,
see.
I would like to produce,
First, let us admit the appeal.
my lord,
Heard, Mr.
Sheila Fazula.
Learned Counsel for the appellant. This appeal under
Section 17(2)(b) of the Mizoram Civil Code Act.
under section 17 within bracket 2 within bracket B of the Mizoram Civil Code Act 2005 related with section 96 and section 151 of the Code of Civil Procedure is preferred against the judgment and order dated 11/9/2025 passed by the learned
First
Track Court cum Additional District Judge Aizal Judicial District, Kolasip,
Yes, my lord.
and the order of attachment dated 11/9/2025 passed in execution petition number 1 of 2025 arising out of LA case number 15 of 2015. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned order dated 11/9/2025 passed by the learned Fast Track Court cum Additional District Judge Aizal Judicial District, Kolasip, in execution petition number 1 of 2025 arising out of LA case number 15 of 2015. Admit, issue notice to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned court below. List the matter after 4 weeks.
My lord, there is a
Then,
stay application, my lord.
Stay, we will see. We'll
I-
pass the order
Today,
today.
my lord, there is an interim prayer, my lord.
Pardon?
Interim prayer, my lord, also. Interim prayer with the stay also, my lord.
No, we'll pass the order.
My lord, then can I place another judgment?
No, why there's a, do you think that this number of judgments you referred will improve your case?
Yes, my lord, since it is with regard to the stay, my lord. And my lord, why I'm pressing this matter so vehemently is that there is an impending decision of the Learned Trial Court cum executing court to pass an order for detention of our officers in civil prison, my lord. So that has to be stayed, my lord, in the interest of justice. Otherwise, our properties will be sold,
No, if we stay the entire order, then
my lord. My lord. If an interim prayer may be there during the pendency of notice, otherwise there is an order, my lord, which I'll just impress upon your lordship again, that is at page 24, my lord. Here it specifically mentioned that detention in civil prison of the judgment debtors is hereby deferred until further orders. There is a next court on 3010. Next court is fixed on 3010. So that is why I am pressing for this stay, my lord.
page number 20,
24.
24 of IA or
In the main appeal, my lord.
main appeal.
Yes, my lord.
Paragraph number?
Para 11, my lord. 4 lines from the top, my lord. Para 11. Meanwhile, detention in civil prison. My lord, if the officers of the state who has to perform the sovereign duties and the public works are to be detained or their properties to be attached, the public at large will be adversely affected, my lord. So that is why I'm impressing upon your lordship to grant this interim stay, at least during the pendency of this notice, my lord.
This is the impugn order.
Yes, my lord.
Okay, we will see.
My lord.
Any other matter?
It's all connected, this 10 to 13 are all connected case, but the execution petition is different, my lord. In the cost list, my lord.
Here,
There are 5
the
cases.
present one is the execution case number 1,
Yes, my lord.
and the others are,
Others are 1, 2, 3, 4, 5.
but the parties are same.
No, parties are different. LA case is also different. But the judgment is the same.
Same judgment.
Same judgment. The parties different. LA case different. Execution petition different, but same judgment.
So in all those cases, the IAs are there.
Yes, my lord.
Okay. We'll pass the order.
Oblige.
Mr. Mehdi, anything?
My lord, yesterday, the one hearing matter, I submitted 2 minor judgment, my lord, and that was mentioned yesterday, my lord. Then today, my lord, I have given to him, my lord.
Okay, okay,
Um,
okay.
2015, my lord, this is what is.